It finally happened. Judge Caldwell lost patience. And when a federal judge loses patience, events unfold fast. What you are about to hear is not courtroom drama. It is not performance. It is a moment when judicial authority reached its limit. In front of cameras in a packed courtroom, a federal judge issued an order rarely heard. Marshals, remove him, now. Federal officers moved immediately, before the sentence was even finished, and then came the moment no one expected. Bail was revoked, on the spot. This was not theater. This was a federal judge declaring that enough was enough. When a sitting judge orders armed marshals to remove a defendant instantly, something catastrophic has occurred. Here is exactly what happened. This hearing was expected to be routine, a standard pretrial proceeding. Nothing extraordinary was scheduled. But Judge Caldwell, a veteran of decades on the federal bench, observed conduct he would no longer tolerate. Courtroom observers reported visible contempt from the defendant, no acknowledgement of the judge, loud whispering to counsel, even laughter during procedural statements. As the court turned to pretrial compliance issues, the defendant interrupted the judge mid-sentence. He stated that the court had no authority over him. The courtroom fell silent. Judge Caldwell paused. Then he issued a single warning. The defendant was told to show respect or face immediate consequences. The warning was ignored. The defendant turned toward the gallery and made a dismissive gesture toward the bench. That moment changed everything. Judge Caldwell's tone shifted, not louder, but colder. He ordered the marshals to remove the defendant immediately. They complied without hesitation. As the defendant was escorted out, Judge Caldwell continued speaking for the record. He stated that the defendant had demonstrated willful contempt for the court's authority. Based on this conduct and documented violations of pretrial release conditions, bail was revoked, effective immediately. This decision stunned the courtroom. Legal analysts reviewing the transcript agree on one point. This ruling was not impulsive. It was prepared. Court records show multiple missed check-ins, alleged violations of a no-contact order. Prosecutors cited social media activity they argued amounted to witness intimidation. The defendant had already received formal warnings. Those warnings expired the moment the judge was interrupted. Judge Caldwell filed a written order within the hour. The language was unusually direct. He wrote that the defendant demonstrated an unwillingness to comply and that continued release posed an unacceptable risk. Here is what the defendant did not understand. This hearing was scheduled specifically to address bail revocation. The courtroom outburst was not the cause. It was the trigger. Judge Caldwell immediately noted this behavior for the record. He stated that the continued disruption would be considered at sentencing if there were a conviction. The defendant was removed, the door closed, the court recessed. When proceedings resumed, other motions moved forward. No commentary, no emotion, only authority. Legal experts are studying this, not because removal is unheard of, but because removal and bail revocation occurred simultaneously. Judge Caldwell combined them. Scholars describe this as a demonstration of judicial authority, a reminder that federal courtrooms are not platforms, they are institutions. This moment was not about a single defendant. It was about the rule of law. When challenged, the system responded. Federal courts will tolerate advocacy. They will not tolerate defiance.